And I am honored to introduce Justice Michelle First and Justice David Watt. Earlier this evening advised Justice First that I brought with me the syllabus. This is the syllabus for Offenses Against the Person, Criminal Law 2, a course offered at Osgoode Hall Law School, which commenced on September 11th, 1989. I've kept this. I've worked with this. It's been a fantastic tool and aid through my career. Helped me become a better lawyer. But part of being a better lawyer is, I guess, keeping up with the law. And I've noted some errors. Maybe you did not foresee your own decisions, but no, that's a bad joke. I apologize. Did I say that I'm up? No. No, I was so impressed by this class. It actually became a wonderful reason to change my career path. Up until that point, I believed that I was going to become an international transaction lawyer. It sounds funny, but my background is in international finance and economics. And I've studied a course under J.G. Castel, who is a member of the International Disputes Tribunal out of France. I've studied under Daniel Prentice at Oxford, who taught me European economic law, and I never thought I'd be a criminal lawyer. So I just want to thank both of you for coming tonight. I want to thank both of you because of the wonderful way that I remember the class that we used to have. I think it was on Thursday nights. I know Jordy Weiss is here. He was in the class with us too. It was always a wonderful reason to stay at school and to attend the class, which was always filled. So I want to share with you what I had the benefit of. And it's not often that you're able to hear from two jurists and two jurists who are speaking together, as they did back in days in August, on topic of criminal law, except if you go to the Federation of Law Societies conferences, which are also fantastic. In any event, Justice First, Justice Watt, thank you.
Thank you. Well, thank you to Paul and to Enzo and to everyone who has worked to put the Garage series together. We think it's a wonderful initiative, and that's why we're here tonight. Enzo, I believe, was the individual who put together a synopsis of the cases that we're going to try to talk about tonight for you. So you have that as a reference point. In the interest of time, we may not touch on all 11 of the cases that you'll see really fall into 9 categories, but we'll cover as many as we can because we want to leave a bit of time for questions from you. The questions can be about the cases, or the questions can be about anything else that for some reason you want to ask this evening. Paul was kind enough to talk about the course that we taught at Osgoode, and in fact David and I over a period of quite a few years taught 2 courses together at Osgoode Hall Law School at night. There was an occasion when a very good friend of our daughter's came over to the house one day, and she said to the 2 of us, you know, there's a rumor going around your class that the 2 of you are having a relationship, which we thought was pretty funny since we were married. But so for those of you who are here tonight who don't know us, if we seem a little familiar with one another, there is a reason for it, and for those of you who are following by webcast, please bear with us. We'll try not to engage in family bickering. So we're going to go a little bit out of order because we want to try to deal with the cases we think may be of most interest and value to you first, rather than some of the ones we've put on the list because we think they're interesting cases, but you may find them a little bit more esoteric. So we're going to start with the topic of searches of computers. And since David likes to say that his computer is always with him, and for those of you who are following on webcast, he's holding up his pen because he doesn't know how to turn on a computer, I will deal with this topic. and then we'll flip over to something he wants to talk about. So there are two cases in this category. They're both decisions of the Ontario Court of Appeal from this year, one of them a very recent decision. The first of the two is the Regina and Cole case. And in that case, the accused was a teacher who had a laptop that had been issued to him by the school board, but continued to be owned by the school board. A computer technician found by looking at the school's server that the accused had some nude photographs of a student on his meaning the computer he was using, its hard drive. The technician went to the principal, who told the technician to copy the photos onto a disk, and also required the accused to hand back the laptop computer. The laptop and the disk in turn were turned over to the police by school officials, and of course the police did what they seem to like to do with computers quite often, which is to search the computer and the disk without a warrant. The Court of Appeal held that the police search of the laptop violated Section 8 of the Charter. Why? The court said the accused had a reasonable expectation of privacy in the contents of the laptop, because even though it was owned by the school board and continued to be owned by the school board, the accused user had the exclusive use of it. He was permitted to make personal use of it on the facts in the case, and he had protected access to it by use of a password. On the topic of the disk, on the other hand, the Court of Appeal concluded that there was no Section 8 violation because the data that ended up on the disk looked at by the police had been found in plain view on the school's server. On the topic of Section 24(2), dealing with the search of the laptop, the court emphasized that the search of a personal computer is among the most invasive of searches, and so excluded the evidence. Why do we think this case is important? Well, as you know, up until very recently, there's been almost no appellate authority on the topic of searches of workplace computers. The topic has arisen on several occasions at the trial court level, and I can tell you that these are difficult decisions when you're trying to apply traditional search principles in non-traditional areas like searches of computer and computer data. You know, many people in their workplaces use computers that have been provided by their employers, not just for work use, but for personal use from time to time as well. And it seems to me that workplace computers are going to be a real potential goldmine of information for the police. So it's good to see the Court of Appeal starting to develop some search parameters for us in this area. I think we're going to see more employers developing written policies that govern the extent to which an employee may use a computer for personal purposes, and the extent to which, therefore, an employee could ever say, I have a reasonable expectation of privacy in a computer that my employer owns and maintains for me. The next case is the more recent of the two, and that's the Jones decision, which you probably have seen, if you haven't read it yet, referred to in the media. It got quite a bit of media play not too long ago, and in that case, the police investigation was a fraud investigation. They got a search warrant, and under that warrant were permitted to seize and to search the accused computer. While looking at the contents of the computer, the police found evidence of child pornography. They then continued, after getting advice from a senior Crown Counsel, to examine the computer, not in terms of the fraud investigation, but now for child pornography. Looking very actively and aggressively for that kind of evidence, they looked in some video files on the computer hard drive that they admittedly would never have looked at had they simply been looking for evidence of fraud. And of course found a great number of images of child pornography. The Court of Appeal held that the search of the video files violated Section 8 of the Charter. Why? The initial warrant had authorized a search of the computer and its data for evidence of fraud, but not for evidence of child pornography. So the Court of Appeal, with Justice Blair writing the decision, said that once the police discovered that initial smaller amount of child pornography, they should have gone back to a justice of the peace. They should have got a second warrant directed to a search for evidence of child pornography. And in particular, the court said, because the Crown tried to justify the search of the video files using the plain view doctrine, Justice Blair and his colleagues specifically said those video files that the police looked in were not in plain view. However, when the court turned to Section 24(2), they determined that the evidence should not have been excluded. The judge at trial had excluded it. The court said that was wrong. And the reason they said it was wrong was because the police had taken the step of going to a senior Crown Counsel and getting some advice on the issue of whether or not they could continue to look for evidence not of fraud but of child pornography. The Crown Attorney gave what was considered to be reasonable advice given the state of the jurisprudence at the time. So even though that advice turned out to be incorrect in hindsight, the court was prepared to say that the police had acted in good faith, and so under Section 24(2) there should not be exclusion. So why do I think this case is important? Well, again, continuing on the theme of searches of computers, there's a very, very good discussion in this decision about the nature of a computer and how and why a search of its contents, of its data, is different than a traditional search. And to some extent, there are some tips in the judgment as to how a search of a computer should be approached. So if you've got a computer search case, look at this decision. It may give you some ammunition to work with in court. David, do you want to deal with the topic of Crown repudiations of plea agreements?
First of all, let me suggest to you that although many of you are at a relatively early stage, some of you at a very early stage of your practice of criminal law, do not be intimidated by the prospects of appearing before our court, the Court of Appeal for this province. It is an excellent experience for you. Don't believe all of the nasty things you read about us in the news media. They're not all true. But I was fortunate enough when I began practice to practice in what's now the Crown Law Office Criminal. It was then, and more appropriately, I think, called the Criminal Appeals and Special Prosecutions Branch. So I had the opportunity in the first week that I was in practice to appear on a motion for leave to appeal to the Supreme Court of Canada, which was the first court I appeared in. It's been all downhill since then. And those motions were argued live at that stage, not on paper as they are now. And the second court before whom I appeared, or before which I appeared, is the court of which I am now a member. So if you have the opportunity to do appellate work, please do not shy away from taking that opportunity simply because you are at an early stage of your practicing career. If you have the chance, take it. Speak to some of more experienced counsel. There are many of them around who appear there on a regular basis. Take their advice, and please come and visit us. We don't we can't guarantee a success, but we'll try our best to give you a fair and considered hearing and decision. The reason why I suggested that the case of Nixon is important is because, as you all know, there are a great many cases in our administration of criminal justice that are resolved by way of agreed upon pleas of guilty. And often they are accompanied by joint submissions on the issue of sentence. Not always, obviously, but in many instances they have. So Ms. Nixon found herself charged with a series of quite serious driving offenses. A couple of counts of dangerous driving causing death, a count of dangerous driving causing bodily harm, and parallel counts of impaired operation. And what happened at the trial stage was that she entered into a plea agreement with the prosecutor. And this case comes from Alberta, and I didn't think they made agreements like this in Alberta. But This was the agreement. She was to plead guilty to careless driving under their equivalent of our Highway Traffic Act, the Traffic Safety Act. She would pay a fine of $1,800, and the prosecutor would withdraw all of the criminal code offenses. Now, this is a case in which 2 people get killed and somebody gets seriously injured. Now, because of the circumstances of the offenses, the prosecutor prepared a report for senior ministry people. The acting assistant deputy minister looked at it and said, "What?" Concluded that the prosecutor didn't really properly assess the strength of the prosecution's case, and said to the prosecutor, "Look, Ace, you're going to have to withdraw this resolution agreement, and you're going to proceed to trial on the counts of dangerous driving." So defense counsel, somewhat chagrined by the disappearance of this excellent deal, brought an application under Section 7 of the Charter alleging abuse of process and sought a direction that required the prosecutor to complete the bargain. The application judge granted the order, said to the Crown, "You have to proceed in accordance with the agreement." Another judge took the plea, acquitted of the criminal code charges, took the plea on the highway safety legislation. Guess what? The prosecutor appealed. The Alberta Court of Appeal said bye-bye to those acquittals and ordered a new trial. The accused then appeals to the Supreme Court of Canada, unanimously dismissed the appeal. Why is it important? Because the court said that the decision taken by, and I'll use the term, the prosecution, to resile from or renege from the original agreement was an act of prosecutorial discretion that was reviewable, but only reviewable on the basis of an abuse of process. And as you, I'm sure, are aware, there are really 2 categories of abuse of process. The first, prosecutorial conduct that affects the fairness of the trial. And secondly, prosecutorial conduct that contravenes fundamental notions of justice and thereby undermines the integrity of the judicial process. And the court unanimously held that a repudiation of a plea agreement could constitute an abuse of process on either one of those 2 bases, although it seems to me one is a little more obvious than the other. Plea agreements, the court said, rejecting a decision of Justice Hill in the Superior Court, are not contractual undertakings, but the circumstances in which the prosecution can resile or renege from those are and must remain, and this is of importance to you, rare. To determine whether the decision to repudiate amounts to an abuse of process requires the judge, on your motion, to examine all of the circumstances. And because acts of prosecutorial discretion are generally beyond the court's reach, because they're not made in the presence of the court, there is a threshold burden on the accused. But that threshold burden, you say, hey, well, just wait a minute here. Why should the accused have imposed upon him or her a threshold burden? Well, the imposition of a threshold burden, you'll see, is not particularly onerous because it's met by proof of a plea agreement and proof that the prosecutor has reneged from it. And if that is established, as it should comparatively be comparatively easy to do, then the evidentiary burden shifts, as it should, to the prosecutor. who's obliged to adduce evidence of the circumstances and the reasons behind the reneging decision. The ultimate burden is on you, as it always is in abusive process cases, to prove an abuse. The court didn't find an abuse here. The critical features were that there was a full-scale inquiry conducted before the instruction was given to renege, and there was no suggestion of bad faith. So what I suggest you take from it is an awareness that sometimes if deals seem too good to be true, somebody upstairs thinks that they are. And there may be circumstances in which the deal will be vitiated by a higher prosecutorial authority. But be comforted at least by the fact that those circumstances in which there can be a reneging, according to the Supreme Court of Canada, are supposed to be extremely rare, and they are subject to control through the operation of the doctrine of abusive process. Michelle?
All right, we'll turn now to the topic of searches of cell phones, another developing area, and the Manley decision, also a decision of the Ontario Court of Appeal. In Manley, the police arrested the accused for armed robbery and also for break and enter. He was carrying a cell phone. During the course of a frisk search, the police took the cell phone from him, opened it up, started pushing the various buttons. Why? They wanted to look at the saved data. In doing this, they found a photograph of the accused holding a sawed-off shotgun that was taken a day after the robbery.
Can happen anywhere.
I have to say I was a defense counsel, but it still continues to amaze me why accused persons pose for photographs, go on Facebook, send emails, do all of the things they do that the police love to inquire after these days. In any event...
Hey, look, it keeps you and I in business. What are you worried about?
The police found the photograph on the cell phone. The officer was concerned that if the cell phone shut down, the photograph would be lost. So one of his colleagues downloaded the photograph to his own cell phone and then in turn to a computer, so it was preserved. And then the police went off and got a warrant to search the remaining contents of the phone. The Court of Appeal found that the police were entitled to do what they termed a cursory search of the cell phone to determine whether it had been stolen, given that the accused was being arrested for break and enter. And they found that there was a link between that offense and an interest in the ownership of this particular phone. So therefore, the Court of Appeal concluded there was no Section 8 breach. What is important, it seems to me, is that the court makes some comments in the course of the decision indicating that it does in fact recognize that in this day and age, individuals have a privacy interest in the data that is stored in their cell phones. And in fact, the court explicitly says that police officers should not and do not have an open-ended power to search a cell phone without a warrant, to search all of the stored data in an individual's cell phone on arrest without a warrant. And the court goes on and says the prudent course for the police to follow in those circumstances is to go and get a warrant to search the contents of a cell phone. So you can see the Court of Appeal going down the path of analogizing the data stored on a cell phone to the data stored in a computer, which is what many commentators out there have been urging on judges. And it seems to me that the importance of this decision is not just that particular analysis, but also the fact that it does put the police on notice from this point forward, that if they simply take a cell phone that they seize from an accused on arrest and start going through it to find everything that's stored on it, they are very likely going to be found to be in breach of Section 8 of the Charter, and I think will probably be in some difficulty on a Section 24(2) analysis. So if you have cases that antedate the decision in Manley. Look at this case carefully, because I think it will give you some fodder for argument about charter breaches. I also think that this decision, along with the ones I've already mentioned about searches of computers, may give us some indication of the direction the Court of Appeal is going to go on when it comes to future variations on searches of computers and searches of cell phones without warrant.
Well, it's also value in determining the way we approach 24-2.
We being...
Yes, I used to be able to decide cases on my own. I can't do that anymore. So if you want the complete answer, you ask Michelle. If you want a third of an answer, you ask me.
All right, so David's going to speak briefly on the topic of the constitutionality and the elements of Section 229C of the Criminal Code, which is one of the homicide provisions. And I suggested that he deal with these two cases, notwithstanding that he was on the panel on the Shan case, and notwithstanding that he authored the Rocks decision, because I think even for junior counsel starting out who are not doing homicide cases at this point, the kind of analysis that went into these two decisions, talking about the constitutionality and the constitutional challenge to a criminal code provision may be of some assistance to you. So, David?
These two cases, Shand and Rocks, involve a section of the criminal code that defines murder, a section that is not utilized with a great degree of frequency. 229C is often referred to as unlawful object murder. And it provides that where a person for an unlawful object does anything that the person knows is likely to cause death, and by doing that causes death, he or she commits murder even though they desired to carry out their object, to effect their object, without causing bodily harm or death to anyone. So we can summarize the elements of this offense, it seems to me, by saying there's a requirement that the prosecutor prove an unlawful object. There's a requirement that the prosecutor prove certain conduct, which in a moment I will describe as a dangerous act. And there is also a requirement that the prosecutor establish a certain degree of knowledge or foresight of consequences. Shand was a jury trial. It was a prosecution for second-degree murder arising out of a botched robbery. And from Shand, we learned that what remains of Section 229C, and what remains is not as it is written, because some of you may recall that a number of years ago, the Supreme Court of Canada, in a case by the name of Martineau, said that the words ought to know, which would create objective foresight of death, were unconstitutional. And we interpreted in Shand the decision of the Supreme Court of Canada in Martineau and some other authorities to stand for the proposition that the minimum fault element that had to be established in a murder case was subjective, actual foresight of the likelihood of death. And we parsed out the elements in this way. Unlawful object has to be something other than the object of causing the deceased's death or bodily harm that the accused knew was likely to cause death and was reckless whether death ensued or not. It had to be an indictable offense requiring mens rea, and it had to be distinct from the act that caused death. The conduct requirement, which I will describe as a dangerous act, must be a specific act or a series of acts closely related to one another. The Dangerous Act can be, most often is, but there's no legal requirement that it be an offense in and of itself, and it must be distinct from the unlawful object. But what is important in these cases from your point of view of defense counsel, because this is often the area where there's most room to maneuver, is the knowledge or foresight requirement. It has to be actual knowledge or actual foresight. Ought to know doesn't cut it. It has to be actual knowledge or foresight of death and the likelihood that death will occur. So there's an element of probability attached with it. But I think importantly as well, and this emerges particularly from Shand, is that we say, and the court had said back in the 70s when this section was a little more frequently used by prosecutors, that this section has to be used with restraint, because you can't force every unlawful killing into murder by some contorted view of the circumstances underlying a killing, to force it within 229C. Because many of these cases, and Rocks is a perfect example. Rocks is an arson case. A bunch of guys decide they're going to torch Woodbine Hardware. It's an unoccupied commercial building because they've cleaned out all of the inventory. The purpose of doing this was to defraud the insurance company. They're going to set the place on fire, submit a claim for the building and the contents. Of course, the contents weren't there, but be that as it may. And on that site, erect a condominium. So the Rocks is the middleman. His job is to go and hire the torch. So he hires two guys, one of whom is a fire suppression expert. Unfortunately, setting fires and suppressing fires are not the same thing. So they're in there spreading the gasoline around in the basement, just like they do in the movies. And like in my hometown, where the last guy out of town shuts off the lights, the last guy out throws in the match. Unfortunately, the building blew up with the fire suppression expert and his cohort inside. The fire suppression expert dies in the fire, and everybody gets charged with murder. That was a judge-alone trial. We substituted in Rocks a conviction for manslaughter because the trial judge made mistakes in her characterization of what the fault element is. And the curious thing about that case is that all of the people involved, whether those who pleaded at an early stage, whether Rocks who went to trial, or whether Mr. Magno who went to trial most recently, everybody got convicted of manslaughter, not murder, which in Magno's case gives you an idea of how 12 people see this, not as a murder case, but as a manslaughter case. Sean?
All right, in the interest of time, Paul, I think we'll do one more short case and then that'll be it. So here's a case I think all of you should have in your little toolkits if you take something to court with you that's some sort of brief synopsis or reference point. It deals with the applicability of the WD instruction. It's the case of Regina and BD. In that case, the accused did not testify at his trial, but did call 3 witnesses in his defense. The trial judge did not give the jury a WD instruction because the accused had not testified. The Court of Appeal held that that was an error and said that WD is not confined to cases where the accused, him or herself, testifies. Obviously, it applies to those cases, but it's not limited to those cases. The court said it applies where there are credibility findings to be made as between conflicting evidence called by the defense and the Crown, or conflicting evidence within the Crown's case because there's something in the evidence in the Crown's case that in fact is favorable to the defense. And something that immediately comes to mind is a statement by the accused that the Crown puts in because it has some inculpatory aspects to it, or something from which inferences could be drawn that inculpate the accused. But on the other hand, from the defense perspective, it also has some exculpatory aspects. So the court has said now in any case where either the accused testifies or the accused doesn't testify but calls evidence on his or her behalf, or even where no defense evidence is called but there's something in the Crown's case that favors the defense and there are credibility issues that that evidence touches on, then the trial judge must give a WD instruction. This is an important case because the jurisprudence was very, very unclear before BD was decided as to whether a trial judge ever had to give a WD instruction unless the accused got into the witness box. So you might want to take a look at it.
And that has to be right. It doesn't make any logical sense otherwise. It seems to me to confine WD to cases in which the accused testifies is an unnecessarily narrow reading of WD. I don't know whether you want us to do one more, or sure.
I found it, so one question I do.
All right, why don't you do you want to do evidence of post-offense conduct, or do you want to do the HIV, that one? All right, evidence of post-offense conduct.
Post-offense conduct, the prosecutor's current darling. Everything is post-offense conduct now. You may recall that in the beginning, to get biblical about this, we knew this as evidence of consciousness of guilt. This evidence of things said or done by an accused after the commission of a crime with which she or he is charged and on which he or she is being tried. And that evidence, if you go back to the early cases, and this all goes back to this decision of the Privy Council called Mawes Con and Reginam. For those of you who are Latin scholars, Reginam being the accusative. 1967 judgment. The evidence was admitted, and if you go back to the basic principles from Mawes Con or from Professor Wigmore's text, it was admitted to show that the accused, after the offense that is charged was committed, acted in a way which, based on human experience and logic, was consistent with the conduct of someone who appeared to be guilty and inconsistent with the conduct of one innocent of involvement in the crime. In other words, consciousness of guilt was used to describe the conduct, rather evidence of the conduct, because it reflected a certain reasoning process, an inference that was going to be drawn. So time passed and we got rid of the label consciousness of guilt and got a new label, post-offense conduct or after-the-fact conduct. And unfortunately, it seems that one of the downsides to this new label is that there's a whole bunch of evidence that's now often urged as falling within that descriptive that, quite frankly, has no place there at all. And in the most recent judgment of the Supreme Court of Canada on the issue, and I suggest that if you're going to read this judgment, it will be a bit of a struggle because there are three separate judgments. And it's one of those where you almost need, you know, those things they used to keep track of, the people who go to the Blue Jays games, keep track of the scores and whether it was a double or a single or what the counts were. You almost need something like that to keep track of it. So what happens in the new White, because there's an earlier one, White's charged with second-degree murder, shooting in downtown Vancouver. During the prosecution's case, the identity of the shooter's a live issue. End of the case, defense counsel effectively concedes, although there's no formal admission, that White shot the deceased, thus committed manslaughter. In the end of the day, then the jury has to decide whether the unlawful killing is manslaughter or murder. So things are going along okay until we get to the Crown's address, which sometimes does cause problems. The prosecutor argued that lack of hesitation, an absence of shock, and a lack of any appearance of uncertainty indicated that this was an intentional killing, thereby murder, as the prosecutor contended, not manslaughter, as the accused said. The trial judge gave a very, very brief instruction, saying you can consider what White did afterwards, but be careful with it. May not tell you much more than that for any number of reasons. He'd be in some kind of trouble if he stayed at the scene and may not be of much assistance to you in assessing his state of mind. White gets convicted of second degree. Majority BC Court of Appeal affirms the conviction. The further appeal, the Supreme Court of Canada, is dismissed by a majority of, ultimately, of 6-3, but on some legal issues, all 9 agreed. On others, a majority of 5, which consisted of 3 who dissented in the result and 2 who concurred in the result, hence my reference to the baseball scorecard, formed the majority. So what do we learn? Well, we learn these things. First of all, evidence of post-offense conduct isn't some special category or special species of evidence. It's neither more nor is it less than circumstantial evidence. And to get circumstantial evidence before the trier of fact, what do you have to show? It's relevant, it's material, and it doesn't offend any admissibility rule. At least the majority, if not the court unanimously, says, look, the great bulk of this evidence is just going to be admitted